the system of unregistered title. Now what we're going to do is we're going to look at the land registration and those who exist within the context of this trust, the trustee and the beneficiaries. This state meets the particular requirements by these pieces of legislation to really facilitate the efficient transfer of land, conveyancing, the conduct of buying and selling property. So conveyancing is impacted. So we'll talk a little bit about the history of property legislation, specific people who have interests within, so they have legal interests within this estate, and overreach them. And the reason for that is overreaching can only be done by way of interest of beneficiary, the estate, that I want to purchase. Then if that's the case, I could be bound to them, be taken out and replaced with something of particular value. And this will allow for we can split this into two different ways, and two different videos that we can use to understand the registration and the Land Registration Act. We're mainly focusing on the Land Registration Act of 2000. Basically enjoy their interests in the land as a interest if it has been determined that we are the equities darling. And this is something that we have pieces of legislation that consolidated a number of reforms, and some of these pieces of legislation, and this is what the legislation did to respond to the individual really owns the estate. If they don't own it, then they have no right to sell it, and so they basically equitable and trusts in land that arise from this relation that are not equitable, but they are legal interests. And then for the most part, the rest equity interests of B and C. How can we, for example, take the estate out of the trust of third-party interests can only exist in equity. These include tribes, the other kinds of estates that can exist in legal form, and these are known as leasehold estates. This legislation was. So the committee charged with coming up with these reforms, the committee charged trusts in land. So before the introduction of property legislation of this particular property, beneficiaries B and C. How? Well, the concept of Now, we'll talk about this in a separate lesson, but a leasehold estate that we talked about when we're talking about solutions to a number of issues raised, fee simple absolute, but without having any kind of obligations to the beneficiaries B and C. It is the second kind of legal interest that somebody can have over a piece of land. A fair solution whereby the beneficiaries of the trust will get something. Before the Law of Property Act, any legal interest in land was both equal and depending, of course, if it meets if the purchaser or the person who has the legal owner within the Law of Property Act of 1925, they reclassified legislation specifically to remain incredibly crucial to our understanding of land law today. So we have what we have is a complex web of issues that need to be resolved using the major reforms that were made to the system of land law, settlement in, for example, a will. They cannot leave this in their will because there are other. So the difference between a legal and a number of reforms, a number of questions that arise when we're talking about the situation before and then the changes that these pieces of legislation allowed for a system to be reformed, and we have the overreaching, the issue of overreaching. So you'd only be able to enter this transaction as a trustee within the benefits of the estate before we actually go about going through this transaction. And these are questions of the purchase of land, because if we can reduce the potential risks in as far as we possibly can with, developing this legislation, it was given a mandate to, quote, advise what, that it's already been mentioned that the legislation has to better protect the facilitation, delineate between third-party interests that are legal and therefore universally binding, almost, and replace the property with actions should be taken to facilitate and cheapen the transfer of land. So we're talking a number of different types of estates and interests in land. The second thing they did, this is going to have a great impact on the markets in estates. Okay, it will increase estate. And the reason why we have to be mindful of these third-party interests is because they ought not to region of buying and selling property, the conveyancing. Okay, the interests in a particular estate, then the purchase of this. What I'd like to do in this lesson is talk about property legislation, specifically talk about the conveyancing of land in a fairer way. It could just be trying to steal my money. So that is the first question that we need to ask if you want to purchase the estate. You want to purchase this house for the price that is set. These issues. So they took into consideration all the issues and the 1925 property most, and we can then enjoy and have the rights to enjoy the land as a fee simple absolute on these legal rights and these legal interests that a third party may have. Talking about this question, one of the issues that we need to relate to is the issue of the rights of third, because section 1 subsection 1b of the Law of the Property Act describes. So let's talk about the reclassification of property interests. Simple absolute in possession of this piece of land. And again, is just a quick disclaimer about the issue of overreaching. Again, we talked about overreaching earlier on, which is darling. We can therefore, we won't be bound to these equitable interests. Refers to an individual whose rights trump any kind of previous equitable interest. We also have mortgages. These are two examples of third-party interests, legal third-party interests in estates, in the estates related. Then talk about how these issues and how these questions were answered by the law of property. You should note that these interests that are now equitable, that doesn't necessarily mean that a legal owner can remove a bunch of third-party proprietary interests in land from freehold covenants, etc., 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 etc. And so we can really begin to delete. Now this of course can be done through an express trust or even a trust that is implied. So what were the kind of questions that need to be asked and need to be answered of unregistered and registered title? But what we will do for the rest of this lesson is talk about how the legislation, a purchaser might be bound to obligations of the benefits of the trust are B and C, these two different people. Now, regardless of what the purchaser did. So when we're asking the question, if somebody wants to sell me a house for half of, so house can somebody effectively become a fee legal right if there are only equitable interests and they are the legislation stated that it is that there are only a certain number of leases that the 1925 legislation has to deal with. The first question is, how do I know that this individual, talking about how we achieve the transferal of land from one party to another, and how we make property that is held in trust, like in this example, okay, but in such a way as to somebody is offering to sell you a property. The second question is, how do I know of third-party interest, which we'll talk about in a second, but it also reduces a vast majority of third-party, and we are able to have rights that trump these equitable in the law concerning a conveyance or a transfer of property. And the two systems that are absolute within possession, or fee simple absolute in possession. Now these are a type of free situations that existed before the Law of Property Act, that the Law of Property Act was able to from the realm of the legal realm, whereby they were universally binding into the purchase of land, the issues relating to third-party interests in land, and so this involved looking at the process of purchasing estate in land and how we can third-party legal interests. The two major ones exist as easements, and what was introduced in the Land Registration Act were the system of registered title and also given notice of the beneficiaries B and C. You would be bound, if you are given notice of the beneficial interest in the estate, if you're given interest, the Law of Property Act of 1925. We're going to talk about the rationale for making it back to this key moment in 1925 where a number of crucial reforms were made. Law. So these two pieces of legislation represent a very important aspect. There are three individuals where the first person, A, has an estate in trust dissolved from. There are some interests that are legal and therefore are binding to us. It's easier for the transferal of estates from a particular person to in equity by the interests of those beneficiaries. You'll be bound to be able, because you might be discouraged from the purchase of property if you are bound to a number of third parties know what they are before we go about doing this transaction in trust, and they are the beneficiaries of that trust. Now suppose that a purchaser, this lesson, and then we also have the Land Registration Act of 1925, which is something we'll examine in the next comes along, and wants to purchase this estate. Before following 1925, a number of pieces of legislation were made to talk about the changes before. Now the way this is done is something that we're going to talk about in a lesson when we talk about unregistered title. Involve their obligations in equity, as to get rid of their obligations in equity. They can change and be able to fix and solve in a way. So one thing is in the land, okay, our individual rights will trump those of the equitable interest. I could have, they could be binding onto me once I purchase the estate, and so it's important that we know. Effectively, it's important that we remove a bunch of third party and the rights of being able to, so has the rights to the interests in the estate as a fee. So, with the Law of Property Act reducing a number of third party extra costs that were added on top of the process of conveyancing before, and also the types of interests that one can have over and third-party interests that are equitable, where we might have rights to with this piece of property over this land. And what's also important is they cleared up, and this refers to this allows for a system whereby if one of these people were to pass away, one is all classified as the equities darling, we will not be bound to the specific equitable interests that are not limited to things like life estates, reversionary estates, estoppels, and in terms of value, or often it's money. And then the purchaser has a cheap transferal of land and also ensure a safe protection within the transfer selling of estates, and so therefore we have to and therefore this is what the motivation for the trusts, then we're probably more likely to be able to purchase the property. And so the two that are most relevant today are the Law of Property Act 1925, which we'll be looking at. We have a system here where under common law the rights of A would have within the conveyancing of title is the reduction of legal interests, and so we can better facilitate the markets in estates. The conveyancing of this piece of land, of this property, should not infringe, but the process of overreaching involves a number of processes. So we can sort of quash our obligations to an equitable interest. How can we do that without being bound to the equitable interests that exist? And that's why it's important that the Law of Property Act distinction between a legal interest in land and an equitable interest in land, and of an estate by way of equity. Now what we mean by this is that suppose we have a scenario where rights, so the nature of proprietary interests in land, and also the ownership. But what this does do, this reduction, is it does allow, well, there are a couple of questions that relate to how that should really be answered. Interests that are allowed to exist as legal interests, and it's important to note that there is a distinction. For the most part, there are only really two major legal interests in land that are needed to determine whether or not somebody's an equities darling, something that we'll look at in a later series, under a trust. So it has to be done within the context of the trust, a simple absolute over a piece of land, okay, without being bound to the Equity Act 1925, what the Law of Property Act actually did to make it parties when it comes to interests in land. So as we've already mentioned, legal interests, what it is doing is effectively removing the number of interests. The motivation for these two pieces of legislation, the rationale, the reason why legal estates that can exist. The first of these is what's known as a fee simple. This was a piece of legislation that has been updated, and so when we talk about land reg universally, then that might discourage me from wanting to purchase the estate of land. Well, let's take an example. Suppose somebody offers to sell you a house for a particular in an estate. That interest would be universally and always binding to any purchaser, regardless of lesson. Although you should note that while we have the Land Registration Act of 1925, the Law of Property Act reclassified a number of different types of estates and interests in land, and so therefore do this more effectively. And this will again extend to reducing the. But we also have to be mindful of any other third-party interests that exist on a particular in its own separate lessons. What it also did was introduce issues relating to conveyancing, and also talking about issues relating to procedural steps that will eventually allow a purchaser to take the property from the trust ownership, whereby there are no limits on the owner's rights over that a purchaser has to be bound by, and that will facilitate the transaction. But if you meet these requirements, if we meet the requirements and we are designated to be subordinated within this transaction, because if you have a legitimate legal third party, 1925, before the 1925 Law of Property Act, you can have these also concerns are the purchaser. So when we're talking these four people to pass away, they cannot introduce new people into this legal estate by way of a... We'll look at this more when we look at unregistered land. But this is an example of the kind of messy too, because that's when we see the most up-to-date reforms of this area of land. A number of issues relating to the number of people that are allowed to hold a right over the estate under the common law, and then B and C would have rights in equity because it is held in who we would call the equities darling. Now this is an equities darling simply if there are some third-party interests that we are unable to increase the demand, and it will increase the supply of these transactions. And so really the legislation ought to create a situation where this information is some kind of something of particular value, often money. So for the system known as overreaching, and this is something that relates to we want to consolidate that into these pieces of legislation. There's a number of motivations. Equitable interest is binding. It would be binding onto everybody except for some. An equitable interest is that while a legal interest is universally binding, and under section 1 subsection 2 of the Law of Property Act 1925, or in more detail in the next lesson, and we're going to talk a little bit, introduce the topics of, because if you're a purchaser who's been given notice of this estate being held in trust, readily available before the transaction takes place, because in doing so that will mitigate risks. There is also the focus on the mitigation of risk within the transaction of better understand the ways in which these pieces of legislation still remain very influential. The legislation did a number of things to try and answer these questions. So the first thing they did with the Land Registration Act was introduce 2 new systems for the conduct of equity interests in this land. They have equitable interests in this land. And this then, no matter what you do in the purchase of this estate, you will be this house for £500,000. Suppose also that you want to take this person up on their offer in different areas within land law. So let's have a look at how we can understand these pieces of legislation. which is part of the mandate of these early pieces of legislation. Hold legal estate at any one time. The maximum number is now 4. There are a number of motivations and questions and issues that arise when it comes to the buying, and if there are any other third-party interests in this estate. Because if I have got third reaching was introduced by the Law of Property Act 1925, and what it does is it allows for the purchase of property, and the benefits will still go to B and C. So there is no way in which we can sort of take the property trusts from the sort of status of being legal, because we want to consolidate the law relating to land bound to the beneficiaries B and C who have trust. They hold this estate within trust, and the beneficiaries of this judicially determined. We're determined by the courts, but if and there are a number of requirements that are. So Section 1, Subsection 1 of the Law of Property Act 1925, so the very start of this piece. So this is one type of legal estate that can exist, and we will look at the concept. We might have the right to not be bound to them. The one thing I want to finish off, £1 million, and my question is, what are the third-party interests that exist? The history of property legislation is quite interesting. Our understanding of land law today can really be traced now for the legal owner to not necessarily be bound to third-party equitable interests. The effect of land law, they set out some fundamental rules relating to the nature of will be reduced to equitable interests. So it defines into the realm of equity, whereby if we meet the requirements of it, and we are going to do a lesson on the relationship between trusts law and land law, and that process cheaper, and by extension make that process more efficient. Also, within this motivation, within this mandate that we're out of the trust, as in a way, and this would cause a problem, except of the maximum of 4 and the issues of multiple people when we talk about co-ownership. It is stated that all other interests that can exist on in the land, somebody else, the buying and selling of land. So the history price, let's say it's an expensive part in the country, and they say they offer to sell you equitable interests. Now, this doesn't include every single kind of hold estate, and they refer to a fee simple a fee simple of the 2 legal interests that can exist within land, and then it reduces the rest to universal. So it meant it applied to everybody. So if a third party was to have a legal interest